Welcome to FOXSOUL's Black Report. This is a space where we bring you Black America's response to the trial and verdict of Derek Chauvin. I'm Romeo.
Hey there, I'm Brooke Thomas.
I'm Demi.
And I'm Melissa.
On today's report, we discuss the Derek Chauvin verdict with civil rights attorney Sue Ann Robinson.
National Bar Association President C.K. Hoffler will also join us to break down the jury's decision and the American legal justice system overall.
Minneapolis organizer Toussaint Morrison and Tyleek McMillan from the National Action Network join us from a rally happening right now in Minneapolis in response to the trial of Derek Chauvin.
We have all of that and so much more. So if you're ready, it's our voice and our truth. Let's get it.
To me, this reeks of conflict of interest.
Do we know if he actually waved a gun? We only hear one side of the story.
This just really did make me feel good that the justice system did what they needed to.
We're going to keep following this story, and we will have the latest for you. Welcome to the show, Showmates. The verdict is in. The jury has found former Minneapolis police officer Derek Chauvin guilty of murder and manslaughter for killing George Floyd. I'll read all three counts. The jury found him guilty of second-degree unintentional manslaughter, third-degree murder, and second-degree unintentional murder. 45-year-old Chauvin was immediately taken into custody after Hennepin County Judge Peter Cahill polled the jury. Judge Cahill thanked the jury, whose identities have been kept secret, saying, "I have to thank you on behalf of the people of the state of Minnesota for not only jury service, but heavy-duty jury service." Chauvin will be back in court in about 8 weeks for sentencing.
Joining us now is civil rights attorney Sue Ann Robinson. Welcome back, Sue Ann.
It's the guilty verdicts for me.
Hey.
I love that energy. So actually, I just want to say first off, on behalf of our entire team here at FOXSOUL's Black Report, the Soulmates as well, we want to extend a lot of gratitude to you for keeping us informed day to day, week to week, from your legal perspective, working closely with George Floyd's family, to also what's going on in the community in Minneapolis. So I just want to say thank you.
Yes.
Thank you. It's been my honor.
Yes. So the verdict is in, guilty on all three charges. What are your thoughts?
Yes. I mean, I'm just so overwhelmed. Initially, it was just like, my stomach dropped and I realized how much emotion I was holding in because, as you guys know, I was in Minneapolis with the family. And just kind of trying to be supportive of them and be mindful that this is, their family member that they lost, but still obviously be vigilant and paying attention to the evidence that was being entered and all the technical details that you have to pay attention to as a lawyer. So today it was just good to take off my lawyer hat for a few minutes with my family home and just kind of have a mini sigh of relief and a celebration. So I'm just glad that the jury did what needed to be done.
Sue Ann, I completely concur with that. I mean, I was at home. I had just put on all my makeup and cried my eyelashes off when I heard the verdict. I found myself really emotional. So I can only imagine what George Floyd's family was experiencing while the verdict was being read. Since he was convicted on all three counts, what does this say about sentencing? There's mention that since the crime happened in front of a minor, that prosecutors will ask for aggravated sentencing, kind of referred to as the Blakely factors.
Right. The state attorney, because Derek Chauvin doesn't have any priors, the sentencing guidelines in Minnesota would dictate, even on the highest charge, which the maximum is 40 years, Derek Chauvin under the sentencing guidelines would be facing about 12 and a half years. However, there's something called an upward departure that the state attorney can ask for based on aggravating factors, such as that the crime occurred in front of a minor, that Derek Chauvin was a police officer, essentially betraying his badge, abusing his authority. So Derek Chauvin actually gave up the right to have the jury decide on those aggravating factors. He waived that right, and he put the determination with respect to the upward departure on his sentencing solely in the hands of Judge Cahill. A defendant has a choice to either have the jury decide on aggravating factors or have the judge decide on that. And Derek Chauvin elected to have Judge Cahill make the decision on those aggravating factors.
So, Sue Ann, we expect to see Chauvin back in court in about 8 weeks. And it's going to take 8 weeks because we have to have what is called a pre-sentence investigation, or a PSI. Can you break that down for us, Soulmates? What is a PSI?
A pre-sentencing investigation will involve someone from the Department of Corrections essentially learning about Derek Chauvin. So they will go to family members, they will go to members of the community who want to talk about him and essentially put together a report about him to present to the judge who is presiding over the sentencing, which is Judge Cahill. So a pre-sentencing investigation generates a pre-sentencing report, and that report is utilized by the judge that's going to be doing the sentencing.
Sue-Ann, once again, thank you for joining us throughout this whole trial. Now, the verdict is in on all 3 counts. We understand what it is. And we would like to think the whole country is embracing that verdict. May not be the case. With that being said, do you think George Floyd's family may need to go into protective custody?
Well, after President Biden and Vice President Kamala Harris called them in on attorney Ben Crump's cell phone and basically offered to bring them on Air Force One, I think that the family is going to be okay. Obviously, you know, our thoughts and prayers are with them always, because we have to keep in mind, even though Derek Chauvin is going to prison, that's not going to bring Perry back. That's not going to bring their family member back. But I'm sure that they are at this moment feeling, you know, elated and hopeful that their family member's life was not taken in vain, that it stood for something, and hopefully it represents change for future cases.
Thank you so much for that. So in your professional opinion, do you think anything happened during the trial that can lead to grounds for an appeal?
I mean, Eric Nelson was not ready. So I don't know if that's grounds for appeal, but he was not ready. You have to understand, typically in police excessive force case prosecution, as I've been saying from the beginning, the state does not come with, they don't even usually bring expert witnesses. So the fact that the state brought not just expert witnesses, the best expert witnesses in the country together for this case, and really put time, effort, and then most importantly, argued the case with the same righteous indignation that they would have for if any other person murdered someone else. A lot of times with police officer prosecutions, the state is not as, you know, into it. They're not arguing with that same voof. And this prosecution team definitely felt that Derek Chauvin should be held accountable. It was felt in every single cross-examination, in their direct examination, and certainly in the closing.
Sue-Ann, you know, we have the benefit of hindsight now, you know, being able to look back at all of the testimony, everything that we saw. Who or what testimonies do you think helped, you know, what were the linchpin in convicting Chauvin?
Honestly, the most compelling piece of evidence in the entire case came from Darnella Frazier, a 17-year-old girl, to most personal cost to herself, emotional cost, stood there with her cell phone in front of those police officers and recorded the murder of George Floyd. That was the most compelling piece of evidence in the entire case. Second comes Chief Arredondo's testimony, the chief of police in Hennepin County, who testified against one of his own officers, who was willing to break the blue wall to say, no, what he did is not reasonable. He's not under threat. He's not in fear. And this is not how he was trained, which I think that testimony was so critical, because typically, again, in police excessive force cases, we do not have other police officers testifying about the behavior and the mindset of other police officers. And I think that really was the linchpin in the case. But all props and everything else to me goes to Darnella Frazier, who really captured the most compelling piece of evidence and exercised such bravery and strength in the face of power. You know, the police officers who she could have herself been afraid of, and she stood there. And if you guys remember, she actually initially faced charges of her own for recording. So I give all the props to that beautiful young Black queen who stood there and spoke to power with her cell phone.
All right, Sue Ann Chauvin's trial is just one of two trials expected when it comes to accountability in the death of George Floyd. The other three officers involved, Thomas Lane, Alexander Kung, and Tu Thao, will stand trial this summer. They are expected to, at least. How do you think this verdict will affect that?
If I was them right now, I would be trying to figure out, can I take a plea? Because I would not want to go against this prosecution team with this win under their wings, with this win under their wings as well. I would not want to go against this prosecution team right now. You know, they have access to the best expert witnesses, and they have the police chief and other police officers who are willing to say, no, that none of that was reasonable. So that puts their case in a very precarious situation if their testimony is going to be that this is how they were trained, or that they thought what Derek Chauvin was doing was appropriate. It's like appropriate based on what? Your chief is here saying that this is unreasonable and this isn't how you were trained. So that failure to intervene piece, that duty to respond, to be a first responder, that's all going to be at issue in the other officers' cases. And so I certainly, at this point, if I was representing them, would be figuring out the fastest way not to have to go against this prosecution team again.
Yeah, that is true. Now, Sue Ann, you were just in Clubhouse with a ton of attorneys known as the New Civil Rights Movement. How's our Black legal world feeling right now?
Yeah, we're all feeling a sigh of relief. New Civil Rights Movement is a club on Clubhouse co-founded by myself and attorney Lee Merritt. And we have a lot of other civil rights attorneys and a lot of community members, stakeholders that join the group. And we opened the room shortly before the verdict was read because we were all collectively just feeling so much anxiety and just wanted to basically spend time together to kind of watch it together, just in case it went left and we needed to kind of vent. But it actually ended up turning to be a celebration and also a call to action. Like, hey guys, this is a very important turning point in our history for ourselves, for this moment in time, for our ancestors, but also it's a point where we have to really take this momentum and keep moving forward in the movement, keep the work going, keep working on legislation, keep working on inside-outside strategies, keep telling people to show up for jury selection, which was so important in this case, tell people to vote in non-presidential elections, keep that movement going so that we can, one, deter officers from this behavior, but also make true lasting reform and change.
I also want to ask you this. We already know Daunte Wright, even during this trial, is when he was murdered, right? And unusable force, what some may call it. At the end of the day, now that we've known what happened, what the outcome was for this trial, could we possibly know for sure we could see the same thing happening in that?
Well, Daunte Wright's case has a different set of facts, but obviously it is an excessive use of force. So I think the important takeaways from George Floyd's case is going to be that the prosecution has to be strong. They have to come with experts. They have to get other police officers to testify with respect to the officer's behavior, whether it was reasonable, whether it was within training and things like that. I think those are the important takeaways from the case that can go into Daunte Wright's case. But also in Daunte Wright's case, they're going to face the same prosecution team, a similar prosecution team, I'm sure, with a similar makeup. And so it's just one of those things where you can, now that we have some police accountability, we're hoping that that means that will spread to all the cases and really make positive, lasting change in America for criminal justice.
So I have a question for you. So before the jurors went to deliberate, Judge Cahill told them pretty much don't let your decision be affected by fear. So something that I've just been very curious to know is what happens next for the jurors. I mean, we haven't seen their faces. We know the makeup of the jury, but we haven't seen their faces. We talked about the security of the family, but do they go into some type of, undisclosed location, or how does that work for jurors in a case like this going forward?
The jurors aren't going to be given any particular security or anything like that. They don't have to reveal themselves unless they want to. So the jurors don't have to ever tell anybody else that they were a juror in the case, that they were worked on the case, what their verdict was, what their decision was based upon. And then on the flip side, if they want to write a book about it, have a show about it, do a reenactment, they can do that as well. So it's completely up to them. It's the individual juror's prerogative if they want to reveal themselves. And I think, you know, with time and kind of their assessment of the community and the environment and how their verdict will affect other things, they will, you know, make their individual decisions as to whether or not they will reveal themselves. I can remember in 1992, Rodney King's verdict, I was 10 years old. And I was watching the TV, and I remember seeing the video. I still have the trauma from it, seeing it over and over and trying to figure out, you know, what is this? This man's being beat up. What is happening with him? Listening to different terms like superhuman strength and because he was on drugs and just different things. And when the officers were found not guilty, watching everyone kind of, you know, protest and watching the city explode and just watching, you know, even over time, Rodney King, you know, as a person functioning and, you know, being a victim of police excessive force. And just as someone who always wanted to be an attorney and is blessed and honored to be in this space, working on what I call the most important work of our time, it was just, I can't even describe in words what it was like today to watch the verdict come in and just see the family kind of breathe that sigh of relief that his life was not taken in vain. And all of us, the community, the activists, the protesters, the people who really put pressure to say, listen, we're not gonna stand by and let George Floyd's life mean nothing, stand for nothing, that his life was taken.
So, Ann, you're absolutely right, especially with the reference that you make, or the comparison, I should say, about Rodney King, because the pervasive message that the prosecution handed to the jury was believe your eyes, believe what you saw, which is evidently what they did. But that was the case with Rodney King. We all saw what happened. 54 or 56 blows were landed to that man's body. He was beaten, he was kicked, he was tased. We saw what we saw, and these cops were acquitted in 1992, 1994. So I feel like I share everybody's, the collective sense of fear to even hold out hope during this time. But one thing that I wanted to ask you is specifically about Judge Cahill. You know, the prosecution and the defense, they got a lot of attention. But what do you think about Judge Cahill and his, him presiding over this case? You know, what was your read on him? Because he was not an easy read, besides the fact that he had a mask on, even the times that he didn't have his mask on. He was not an easy person to read. So I think that we're now drawing questions as to what kind of sentencing is he going to hand down.
Mm-hmm. I think Judge Cahill is honestly a judge's judge. He wanted his courtroom to be tight. He was getting aggravated and frustrated when he felt like things on the outside of his courtroom were possibly having influence on his courtroom. But if you remember, whenever those motions were brought up, he swiftly evaluated them and tossed those things to the side to let people know, I'm the referee in here, I'm the judge in here, I'm the one who's in control of this particular case at this time. It's going to be in the hands of the jury to make the determination on conviction, but this is my courtroom, and he didn't tolerate a lot of nonsense, even though they had a gaggle of sidebars, and there were obviously objections throughout the case. He was very, he stayed in the same emotional kind of vein and kept it straight. The only time I had an issue or thought he was going a little far was when he made the comments about Maxine Waters. But I'm going to say this, Judge Cahill definitely set a precedent in his jury selection by not allowing the fact that prospective jurors said they were in Black Lives Matter, or they had positive thoughts towards Black Lives Matter, or they were aware of the marginalization of Blacks by police officers and things like that. He didn't allow jurors articulating those kinds of concepts and things to be a reason for them to be stricken from the jury. Typically and historically, those types of responses during voir dire lead to jurors being kicked out. So then what's left on the jury are people that don't respond to those things or don't have any knowledge of it, or say they don't have any knowledge of it. And so for Judge Cahill, to me, it seemed that he was very pioneering in that regard, to have not allowed that to be a reason to strike a juror for cause. So overall, we'll see what happens in the sentencing. I don't want to call it too early. I feel like there are a lot of aggravating factors, especially because the judge has knowledge that the jury didn't, in terms of Chauvin's record and things that were discussed about Chauvin specifically at sidebar that the jury has no knowledge of. So it's interesting that he's going to be charged with, doing the sentencing when he has that additional knowledge that the jury didn't have. So I'm curious to, as everyone else is, to see how it turns out.
Sue-Ann, thank you so much for joining us in the past weeks. We truly appreciate you.
Absolutely.
Thank you guys so much.
All right.
Be blessed. Celebrate, you guys.
Yes. It's
and let's keep working. Bye,
absolutely.
soulmate.
The work is definitely not over.